I'm Matthew Gibney, and I'd like to welcome you to this, the Refugee Studies Centre's weekly seminar in forced migration. Tonight is our penultimate seminar for Michaelmas Term, and I'm pleased that our speaker tonight is Deirdre Troy. Deirdre is a PhD student in politics and international relations at Queen Mary, University of London. Her most recent publication is Governing Imperial Citizenship, a historical account of citizenship deprivation, which was published in Citizenship Studies last year. I first met Deirdre at a workshop on citizenship deprivation and banishment at the European University Institute in Florence a couple of years ago. And I felt immediately that her work, which richly combines historical analysis of UK citizenship with a strong sensitivity to themes of race and empire, would be of great interest to the Refugee Studies Centre's audience. And not least so in a week in which the issue of the treatment of the Windrush generation under the hostile environment policy has been opened up again, and in a week that the case of Shamima Begum confronts the UK Supreme Court with its issues of the legitimacy of stripping citizenship. So Deirdre's talk tonight is Belongers and Non-Belongers, Dividing Citizens in 1968, and I'll now hand over to her.
Thank you. Thank you, Matt, and the Refugee Studies Centre for the invitation. And Matt, thank you for that incredibly warm introduction. I am really excited to share with you this paper that I've been working on, which is based on my PhD research. So for background, this paper is taken from my research on citizenship revocation, which is the practice of stripping citizens of their citizenship. Let me just start sharing the screen. Okay. So I explore this practice in the context of its imperial history. My research addresses the literature on citizenship revocation in political theory that focuses on questions such as whether revocation can ever be justified or whether it's in tension with liberal and democratic principles. The following paper builds directly on archival research that I've done over the course of the PhD, where I've examined government memorandums, policy documents, and parliamentary debates related to the Commonwealth Immigrants Acts of 62 and 68. In searching through the archives, I came across the creation of this new category, the belonger. And while some of the key contributors on British citizenship and post-war immigration detail the importance of belonging as part of the Immigration Acts, belonger remains an underexplored concept in this literature. I believe that the analysis of this category, belonger, provides new insights for the study of revocation. So let me just... In this literature, revocation is presented, in the literature on citizenship revocation, revocation is presented as creating a hierarchy or a two-tiered system within a common status. Citizenship may be stripped from some citizens, for example, those who are naturalized and or hold dual status. And in this sense, revocation acts as a dividing practice, restricting the mobility of some citizens but not others. I find that in much of this scholarship, the terror security narrative that accompanies revocation is rarely challenged. Citizenship is stripped because of the exceptional circumstances of international terrorism. But I argue that there are other important elements of revocation that should be considered. At present, when cases of revocation are reported, the ethnicity, religion, or race of the citizens involved becomes a focal point. While this may be to ascertain whether the individual has another form of citizenship which would prevent the government from rendering them stateless. Their ethnicity or race is often repeated as if to offer meaning to the practice. This reinforces an idea central to revocation, that these citizens belong somewhere else. This is despite the fact that, as seen in the recent case, or the ongoing case rather, of Shamima Begum, some of these citizens are natural-born British citizens. While some recent publications on revocation have noted that discrimination may be a factor, and here I'm thinking of Tufial Choudhury's paper, Elka Winter and Ivana Prevasic, and a recent publication by Matthew Gibney, I bring the divisions within citizenship that are visible through the practice of revocation into sharper relief. In this paper, I move the analysis of revocation away from a terror security narrative to consider practices of division and belonging. I do this by examining another point in Britain's history, when citizens were stripped of their citizenship rights and told they did not belong. I explore archival material related to the Commonwealth Immigrants Acts of 1962 and 68, when citizens who held citizenship of the United Kingdom and Colonies were divided, and some were denied the right to come to Britain. In drawing attention to this historical case, I link revocation to a longer history of imperial practices and show that the hierarchies within citizenship that revocation both relies upon and reproduces are not new. These hierarchies are historically embedded within citizenship in Britain, and the practices that sustain these hierarchies are still in play today, albeit in different forms. Through this, I argue that as much as citizenship is a status of equality, it is also one of hierarchy. The hierarchy is evident when the status of citizenship is replaced with arguments of sameness and difference and categories of belonger and non-belonger, as I'll detail below. This hierarchy must be considered, I argue, when theorizing on citizenship. In the following paper, in the next section, I'll outline why I believe these immigration acts are worth revisiting for a study of revocation. I'll then provide a different account of the history of these immigration acts, focusing on the creation of the belonger-non-belonger distinction. Finally, I'll conclude with an analysis of why this history matters for revocation. So at first, the differences between immigration and revocation powers may seem pronounced. Firstly, rules governing revocation exist as part of the British Nationality Act, whereas immigration acts fall under a separate piece of legislation. Immigration acts, as indicated in the name, are designed for immigrants who may typically be categorised as non-citizens, with the purpose of restricting their mobility in relation to the state. By contrast, revocation powers are directed towards citizens, though these powers also seek to restrict mobility in relation to the state. However, as I detail below, the Commonwealth Immigrants Acts were used on citizens of the United Kingdom and Colonies to restrict their mobility to Britain. Though immigration acts may be assumed to govern non-citizens, in this case, they very much govern citizens. As Sandra Mantoux finds, while citizens from the colonies were not formally deprived of their status as citizens, their citizenship was to a certain extent ineffective. Rendering citizenship ineffective is recognised as rendering citizens de facto stateless, as the citizenship they have cannot be used. So as was decided by the conference that drew up the 1961 Convention on Statelessness, persons who are stateless de facto should, as far as possible, be treated as stateless de jure to enable them to acquire an effective nationality. While the Immigration Acts did not strip formal citizenship, the Acts stripped one of the most important features of citizenship, the right to enter the state of which that citizenship is attached to. This was particularly vital for East African Asians who were the target of the 1968 Immigration Acts, as they were fleeing persecution in the late 1960s. Although immigration and revocation powers concern different laws, in the 1960s and 70s they perform a similar function. These immigration acts were used to divide one citizenship status with the purpose of restricting the mobility of one group of citizens, but not the other. Recognizing some of the similarities in function between these laws, I'm interested in how this division was made possible. I explore how the government managed to introduce a law that divided one citizenship category in two. In the following historical account, I suggest that what provides real insights is this belonger non-belonger distinction. These categories took the place of terms such as citizen and immigrant to divide those who were accepted from those who were not. Okay, so I'll move on to the historical research. In 1948, a British Nationality Bill was passed that confirmed a pre-existing right of entry to all British subjects, now termed Commonwealth citizens, to the UK. This was an uneasy right, as analysis of the archives point to a persistent belief in the British government that subjects around the empire should be divided in several ways and their mobility restricted accordingly. Though Britain always pursued a hierarchy within a common status under subjecthood and claimed at an imperial conference in 1937 that subjects from, quote, separate jurisdictions, territories and races, end quote, could not be included under one form of citizenship, it reversed its position temporarily. Under the 1948 bill, it grouped citizens from the colonies with citizens from the UK under this status, citizenship of the United Kingdom and Colonies. However, once those from the new Commonwealth countries or colonies acted on this citizenship and began to arrive to Britain, the government decided to remove this right. The reason for this reversal are worth revisiting from the perspective of revocation. Now, as historians have documented in detail, there was a labour demand in Britain following the war. And in 1946, the Foreign Labour Committee was tasked with increasing the use of foreign labour. Europeans, otherwise classed as non-citizens, were viewed as one source of labour, and different schemes and policies were introduced to ensure their arrival to Britain. Polish resettlement schemes, European volunteer worker schemes, private domestic worker schemes were all used to bring people from Europe to Britain. All of these contributed to the foreign population in the UK, with a conservative estimate of non-citizens recruited under the Attlee government of 1945 to 1951 at 345,000. Now, a considerable number of immigrants to the UK were Irish, and this group would play a significant role during the immigration debates of the 1960s and 70s. By 1951, Britain was home to 750,000 Irish-born people. However, an increase in immigration from the colonies was viewed differently. That immigration was not decreasing was presented as a problem, yet it was also stimulated by the recruitment of transport and domestic workers. For example, in the early 1950s, the London Transport Executive had sent a recruiting mission to Barbados, and British Railways were also looking to recruit citizens there. While there was reportedly little evidence of any difficulty of arrivals finding work, the committee pointed to an issue of overcrowding and housing. This is despite the fact that during the 1950s and 1960s, more people left the country than entered each year apart from 61 and 62. By continually counting citizens arriving from the colonies, the government began to refer to these citizens as a problem, whereas they were unconcerned with the figures of those arriving from the old Commonwealth countries such as Canada and Australia. And so they wished to find a way to separate citizens from the colonies from immigrants from elsewhere. Now, unless a new British Nationality Bill was passed, the government would have to divide this one citizenship category into two in order to regulate the mobility of one but not the other. And with these claims over housing and social tension, the government introduced a new immigration bill in 1962. In designing an immigration bill for citizens, distinctions between these legal categories of citizen and immigrant broke down during this period. That is, in deciding to use an Immigration Act on citizens of the colonies, the British government took the crucial step to treat its citizens as immigrants. Privately, cabinet ministers recognised that new restrictions would, and I quote, operate on coloured people almost exclusively, end quote. So the Immigration Act of '62 was introduced on the basis of belonging. In the efforts to explain what was meant by this, the Home Secretary told Parliament in 1961 that the objective was to accept from control and therefore to guarantee their continued unrestricted entry into their own country, persons who in common parlance belonged to the United Kingdom. He continued that this was to be achieved by accepting first persons born in the United Kingdom and secondly persons holding passports issued by the United Kingdom government. As the bill was introduced to Parliament, MPs pushed for clarity on who the bill was actually aimed at. The Attorney General initially suggested that the bill was drawing a distinction between residents and non-residents. However, he was challenged on the status of those born in the UK who no longer lived there. According to the records on the parliamentary debates at the time, the Attorney General then suggested that the easy way, the colloquial way of putting it, was to draw a distinction between the belongers and the non-belongers. He said that the term resident was too narrow a distinction, whereas he believed the belonger distinction to be better and necessary to control immigration. Now, in coining the belonger-non-belonger distinction, the Attorney General was essentially creating a new category which had no real legal basis, but would nonetheless be used to justify new legislation. Members of the opposition reminded Parliament that the bill concerned British people and said that the government had not presented a bill to amend the Nationality Act. As a result, those who would be subject to the Immigration Acts were still citizens of the United Kingdom and Colonies. It was argued that, quote, "They have no other nation. We have not granted them independence. They are part of us." Another MP said that the government was effectively, quote, "legislating against the entry of our own fellow citizens into our own country," end quote. But the Attorney General claimed that it was perfectly true that no one liked the bill, and that it was a sad necessity, but that the government would be failing in their duty and their responsibility if they failed to tackle the problem. This problem that they continually refer to is the problem of immigration, of the immigration of non-white citizens. The decision not to regulate the mobility of the Irish to Britain further complicated this meaning of belonging and the category of belonger. The decision was explained by pointing to what was perceived as Britain's close association with Ireland, geographically and, quote, "for every other reason." Though they did not hold citizenship of the United Kingdom and Colonies, the Irish were counted, according to the government, in the same category as the ordinary inhabitants of Great Britain. As an immigrant group, they were frequently compared with those travelling from the colonies. The government believed that although the Irish lived in conditions the English wouldn't tolerate and had caused complaints with local authorities, it was claimed that the same difficulties did not arise in the case of the Irish as the case of people from the colonies. So you can see this kind of hierarchy being reproduced through these comparisons. The repositioning of the Irish under the desirable category would allow for a continued labour supply from Ireland, while the argument of sameness meant that they would be exempt from immigration restrictions. So by the late 1960s, the government referred to the belonger distinction more frequently in support of its immigration policies. The desirable subject was no longer described as a citizen, but a belonger. This new distinction quite explicitly created a hierarchy within one's citizenship status, as within one status, some citizens were now belongers, while others were non-belongers. The government would not only use this distinction for the purposes of immigration restrictions, it would rely on it to override international agreements. In wishing to introduce further restrictions in 1968, the Home Secretary recognised that if the mobility of citizens of the United Kingdom and Colonies in East Africa was restricted, they would be left with, quote, no more than a husk of citizenship. The government knew it faced difficulties internationally, as the 1968 proposal defied several international agreements. There was a general international understanding that states had an obligation not to refuse admission to its own citizens, and it was contrary to international law for states to deny entry of its own citizens if they had been expelled by another state of which they held no citizenship. The list of international agreements relevant to the 1968 proposals that the UK had signed, ratified, or was in the process thereof included the Universal Declaration of Human Rights, the United Nations Convention on Racial Discrimination, the International Covenant on Civil and Political Rights, and the European Convention of Human Rights. Of these international agreements that Britain looked to be in breach of, it viewed the most pertinent to be the European Convention. Article 3.2 of the Fourth Protocol read that no one shall be deprived of the right to enter the territory of the state of which he is a national. At this time, citizens of the United Kingdom and Colonies had already brought cases to the European Court over the 1962 Immigration Act. And the government believed that more cases could be brought if the 1968 bill was passed. And while the focus was on the European Convention, each of the agreements listed contained similar articles regarding the mobility of citizens. Now, the archival documents that I examined show that with regards to the UK position within international law, the Attorney General thought it was difficult, but not impossible, for the UK to defend its case. The government could argue that those subject to the bill did not, quote, in any real sense belong to the country. While the greatest challenge came from the European Convention due to the specificity of its terms, the Attorney General said that the UK would rely on arguments that pointed to the anomalous nature of citizenship of the United Kingdom and Colonies. By anomalous, they were arguing that this form of citizenship was not like any other citizenship which was represented by international agreements, nation-state citizenships. This anomalous nature was in fact its imperial nature. In wishing to bypass international nationality law by pointing to this anomalous form of citizenship, the suggestion was that this was an imperial problem that called for an imperial solution. By pushing this argument, the government bypassed these international agreements and treaties to introduce laws that would remove the right of entry for some citizens, thus rendering their citizenship ineffective. So, as you can see from that picture from the archival documents, the 1968 Commonwealth Immigration Act was introduced to curtail the mobility of citizens in East Africa and to, quote, bring these non-belongers within the scope of control. Given that the Act would be used against citizenship of the United Kingdom colonies in East Africa, seeking to leave state for fear of persecution, the Act was even more controversial and devastating than the last. By removing citizens' right of entry to Britain, the country attached to their citizenship, the government was in effect creating stateless citizens, a contradiction in terms though oddly fitting within imperial politics. In Parliament, United Kingdom belongers was loosely defined as those who belong and have associations with the UK. It was said of citizens in East Africa that, quote, these particular citizens in Kenya are not United Kingdom belongers and never have been. The suggestion of racial prejudice was dismissed, as it was argued in the House of Lords that the fact that the immigration restrictions will apply mainly to those who are of a different colour is because it will apply to those who have not been belongers to the United Kingdom. When asked if white Kenyan citizens would be included in the bill, Lord Shackleton answered that it depended if they fell within the definition of United Kingdom belongers, a phrase which did not, admitted Shackleton, appear in the bill. When pushed for an explanation of this term, he said, and I quote, It was one of those ugly words whose meaning, however, is quite self-evident. Another member of the Lords objected to the bill, viewing it as nothing less than a decree of statelessness for every Asian in Kenya who is not admitted to this country. Baroness Asquith of Yarnbury added that the creation of a new privileged class of belongers added insult to injury. After asking what a belonger was, the Baroness was told that to be a belonger you needed an English grandfather. But she noted under these terms the Duke of Edinburgh would not qualify. Maintaining that the bill was racially discriminatory, she commented, "A belonger usually has a white face." The Baroness was not wrong, for as noted, the Irish who were legally non-citizens would not come under the control of this bill, thus positioning them within the belonger category. In response to the Baroness's critique of the term, she was told that, quote, "She herself is a belonger. We are all belongers." Shackleton then claimed that the term belonger was a well-established phrase. Others expressed surprise at the request for a definition of the word belonger, commenting that they thought it was fairly clear. There was a dismissal of objections during parliamentary debates over the creation of two classes of citizenship, as it was argued that this already happened under the 1962 Act. But there was also a recognition that this situation was different, as these citizens had nowhere to go. The Act placed citizens in a dangerous and potentially life-threatening position by removing the rights attached to their status, thus rendering them de facto stateless. With the passing of this 1968 bill, the government created 200,000 stateless citizens. While the Immigration Act was directed towards the citizens of the United Kingdom and Colonies in East Africa, it should be noted that not all of those who held that status in East Africa were non-belongers. As a later archival document revealed, in 1972, the Foreign Secretary reported that there were 4,000 belongers in Uganda. These were white citizens who had the freedom to travel back to the United Kingdom. Okay, so I will stop sharing and I will go into my conclusion. So, to conclude, in this paper I argue that while Revocation and Immigration Acts are not the same, there are aspects and functions of these laws that overlap, such as the stripping of rights, the question of belonging, the division of citizens. In this conclusion, I wish to explore 2 points further. Firstly, I look at what we learn from the belonger category for the study of revocation, and secondly, how this history shapes our understanding of citizenship theoretically. What is striking about the belonger division is the attempts by those defending the 1968 bill to appeal to an intuitive sense of belonger, and the idea that if MPs really thought about it, they would know who a belonger was. This was taken a step further when it was claimed that it was a well-established phrase. The term belonger appeared to have been coined by the Attorney General in 1961. It was relatively new. However, its meaning had a long lineage in the history of citizenship and subjecthood within empire. Shackleton revealed what belonger was intuitively appealing to in 1968, that citizens categorised as anything other than white did not belong in the UK. While a notion of belonging is often associated with conceptions of citizenship, the historical analysis presented in this paper emphasises the racial connotations behind this word belonging. Nationalistic language was introduced by those in power to let it be known that citizens from the colonies were unwanted. And this language was employed to justify laws that would be used against them. New terms such as belonger and non-belonger were presented as self-explanatory words to distinguish between the tiers of citizenship, between those who apparently had a right to be in Britain and those who did not. Belonger remained a legally undefined word spoken by legislators, repeated to the public, but omitted from the acts. The unsettling consequence of being labelled a non-belonger resulted in citizens in 1968 having nowhere to go, as the country to where they legally belonged rejected them. At this point in history, belonger and non-belonger superseded the categorisation of citizen and non-citizen, as one citizenship status was divided in two. Citizenship status was replaced by categories of hierarchical sameness, as witnessed in the case of the Irish, versus hierarchical difference. While these acts did not strip formal citizenship, they did render some citizens of the Empire stateless, as in the case of East African Asians. The government knew perfectly well that it was in violation of several conventions and treaties related to the protection of nationality. Nonetheless, it pursued these immigration acts relying on the belonger distinction. Reflecting on the international treaties and conventions that were bypassed in this history, this analysis cautions against the reassurance that legally human rights norms protect citizenship by pointing to the hundreds of thousands who were rendered de facto stateless a few years after the 1961 Convention on the Reduction of Statelessness was ratified. Returning to the contemporary cases of revocation, despite the dominant terrorism security narrative associated with the practice, with this historical vantage point, the emphasis on belonging and otherness are brought into sharper relief. As witnessed in the ongoing case of Shamima Begum, a British-born citizen's legal status is dependent on her ability to prove that she does not belong somewhere else, in her case, Bangladesh. While a focus on the terror security narrative provides one framework through which to understand the practice, it alone does not explain the politics of revocation. And finally, to a broader point that I've been exploring through, I guess, the PhD on the back of the archival research, is to the study of citizenship. By revisiting this history, I argue that revocation has precedence in imperial practices. The historical analysis of this paper draws on the divisions and notions of belonging within citizenship. It argues that revocation follows a history of imperial political legal frameworks and practices that divide subjects and reproduce categories such as the non-belonger. The historical analysis has consequences both for how we understand revocation and British citizenship today. So, for example, we learn from the literature on citizenship revocation that citizenship is a status of equality, and that, in a sense, revocation deviates from this norm. However, as this historical analysis has shown, as much as citizenship is a status of equality, it is also one of hierarchy, and this hierarchy is inherent to the status. As witnessed in this history, the differences of citizen and immigrant were replaced with arguments of sameness and difference, and categories of belonger and non-belonger. The rapid dismantling of the citizenship in the United Kingdom colonies category exemplified in a brutal way how citizens with the same status could be treated differently according to these created and controlled racial hierarchies. Okay, thank you.
Great, thank you so much, Deirdre. That was really fantastic and highly informative.